is Jodi Ginsberg of Ginsberg Law Offices, and I want to talk with you today about a recent case that just came out. It is not very helpful to injured workers, and you have to be very, very careful. What we saw in this last case that just came down recently is the fact that an individual went to work. He had been injured at work, and everybody knew that he had been injured at work, and he had certain restrictions placed upon him. Let's say it was, I don't remember exactly in this particular case, but let's say it was no lifting over 25 pounds per the doctor because he had an injury. And his boss knew that, and in actuality his boss said to him, I don't even want you to lift anything. Don't lift anything. Don't lift 10 pounds, don't lift 5 pounds, don't lift anything. And for whatever the reason, this injured worker decided that he needed to do something. And he was one of these guys who said, well, I'm here to work. I'm not here to just sit around. So I'm going to go ahead and do certain tasks. Now, wound up that he continued to do the tasks. He hurt himself again. And he hurt himself again. And ultimately, the judges decided that his termination was valid for insubordination, in that he should not receive any income benefits because he did not listen to his boss. His boss, and usually we don't see this. We usually see bosses telling folks, oh, you have a 25-pound lifting restriction, go over there and lift this, and it turns out to be 30 or 40 pounds, and they tell him to go do it anyway. In this case, the boss said, don't lift anything, and this gentleman continued to lift. And so what the judge found, and this went all the way up on appeals, and it came down in the Court of Appeals, and they said, look, if you're told not to do something, don't do it. So I'm cautioning everybody out there, if you have certain work restrictions, keep them in your pocket, and if your boss tells you to not do even that, and lift even less and less, you're going to have to really be careful about what you do, because they're going to try to find a way to fire you. They always try to find a way to fire you when you're on light duty and suggest that it has nothing to do with your work injury or your light duty limitations, but something else. And in this case, it was insubordination. They'll look for ways to fire you because you violated company policy and every other reason. Don't give them that way to fire you, because you're going to really impede your case in a very poor way, both from a current stand in terms of getting weekly benefit checks and future values in terms of settlement. If you want to speak about your particular situation at your workplace right now, please give me a call. I'm at 770-351-0801. Thank you. Hi, this is Jodi, and I hope you found this video helpful. If you'd like to know more about all rights and benefits available to you under the Georgia Workers' Injury Laws, I'd like to invite you to download my Georgia Workers' Compensation Survival Kit that I created for folks just like you. Some of the topics I cover include: can I get fired for filing a work injury claim? 8 critical mistakes to avoid. Is it true that the insurance company will hire a private investigator to follow me around and videotape my activities? What happens when the insurance company is late with my weekly wage payments? 7 specific tactics I recommend to maximize your case settlement value. If you or a loved one needs to maximize your recovery from your Georgia Workers' Compensation claim, you'll find this Survival Kit important reading. Download your Survival Kit right now and at no cost. Just visit my website and sign up. It's that easy. Please act now, and as always, I wish you the best.